we still struggled and had 2 or 3 hearings to convince a judge that we should have possession of that property because the tenant was not appropriate, was not complying with the terms of their tenancy, and was actually a problem for the community. So ASB was always problematic. I guess it's judgmental, very difficult to prove. It's easier to prove someone owes 3 months' rent or 2 months' rent than it is to sort of prove someone is causing ASB. But what they've said, they will create a new mandatory ground. So this is where the judge has no choice. If we can prove, the judge must award possession, but the burden of proof will be on us as landlord to prove. But what they've said, and this is the nice bit, we in effect do not have to issue any notice to the tenant. So if we had an extreme antisocial behaviour case, we could immediately make an application to court. So there's no 2 or 4 month wait. And sadly, this will happen on occasion. I know there's a national case that made the landlord press, which was a domestic violence case. And the person who was, in effect, not the victim, but the person causing the domestic violence, under current tenancy laws, could not be prevented from entering that policy. They had rights on the tenancy, and the victim couldn't be protected. Now, these changes would speed up ability to sort of protect that victim in this case. So if we had such a case, we could make an immediate application to court to gain possession. At the moment, actually, we would still have to give a number of weeks' notice. So that is actually a small win if and when we have ASB. Ironically, in the past, a lot of landlords, and we've even done it as a letting agent, rather than go to court and try and prove antisocial behaviour, we would use Section 21 and just say we just want possession of our property and almost ignore the ASB, because it was easier to win a court case based on other grounds than it was to genuinely prove to a judge that antisocial behaviour was taking place. So that's a route that many people have taken in the past, but certainly the strengthening of ASB rules is one of the few things that I would welcome amongst everything we're talking about. So that is one positive, I'm pleased to say. I'll pause for a second, Baxter, if you have anything. Sorry about the
Yes, I do there, yeah. So this is in regards to it's obviously, but is that a police disturbance or a court appearance?
For the antisocial behaviour, is that, sorry?
Yes, ASB, sorry.
The ASB. So I'm not, maybe if you can get some clarity on that, I'm going to answer the question. Yeah. I'm going to answer the question I think's being asked, but if we struggle to get to the bottom of this, Baxter, on the call, maybe book a call for me, if that makes sense, because I'm not entirely sure what's being asked, but if I understand correctly, it's the fact that we could apply immediately to court, so it's not a police appointment. What they're saying is, at the moment, if we identify ASB, we would have to issue a notice to the tenant, and only on expiry of the notice, only then could we apply to court. What they're saying in this legislation is, where we feel we have a strong case, we could immediately simply apply to court. So it takes away the notice period, so it will make possession for ASB quicker, which is one of the few positives that I can point to in all the renters' rights bill. I'm going to leave that with you, if that's okay, Baxter. See if I'm hoping I've answered the right question, but if not, maybe book a call in for me if that's okay, and I can try and answer in more detail. So I'll move on to the next.
Will do.
We moved a number of sort of changes now, some less problematic than others, but there's the implementation of a property ombudsman